Hey there, justice fans. Welcome back to the Baby Criminologist, the only legal podcast hosted by someone whose brain isn't fully developed, but still manages to make more sense than the U.S. Supreme Court. Let me ask you something. If someone in a federal uniform allegedly assaults you while you're locked up, what do you think happens? Answer: nothing. What happens if that inmate tries to sue? Answer: also nothing. What happens if I stage a filibuster to delay bath time using only loud babbling and a Titanic tantrum? Answer: timeout. Immediate. So I ask you, why do I have more accountability in my onesie than some of our federal officers? Recently, in a 6-3 decision written by Justice Clarence Thomas, who apparently thinks accountability is an optional side quest, they ruled that unless Congress specifically creates a law allowing people to sue, you're out of luck. No lawsuit, no civil recourse, not even a, sorry we rearranged your ribs during lunch hour. It's like if someone steals your teddy bear and the police say, we get it, that's unfortunate. But unfortunately, we've decided teddy bear theft isn't really in our lane. The man, named Abdus Shahid Moro, claimed he was assaulted by correctional officers while in a U.S. penitentiary. He tried to sue under a legal theory called Bivens, which stems from the 1971 Supreme Court decision that basically says, hey, if a federal officer violates your rights, you should be able to take that to court. Sounds reasonable, right? The majority said, well, this kind of lawsuit might mess with how prisons function. Right, because nothing ruins a prison's vibe like consequences. If Bivens was a bedtime story, the Supreme Court just ripped out the last 10 pages and replaced them with a shrug emoji. What does this really mean? It means if you're brutally assaulted by a federal officer, say, a prison guard, you can't sue them. The door to justice just got baby-gated shut. Let's be honest here. This ruling doesn't just slam the courthouse doors shut. It bolt-locks them, paints them the same color as the wall, and says, what doors? And look, I get it. You might be thinking, well, they're inmates. They did something wrong. Why should they sue? Because basic rights don't vanish with a conviction. We don't toss out the Constitution just because someone made bad choices. That's not law. That's toddler logic drawn in crayon and handed over with a smug, told you so grin. Imagine this. I smack another baby in the sandbox. The teacher sees it and says, well, we didn't have a policy about sandbox smacking, so let's just move on. That's this ruling. Except, instead of babies, it's adults with authority, weapons, and no consequences. This ruling, it isn't just about one case. It's about a future where federal power grows but public protection shrinks. I might not know how to read Latin, but I know that if justice only applies when it's convenient, it isn't justice at all. So here's what I want you to do. If this ruling bothers you, speak up. Call your reps. Demand legislation that brings real accountability to federal officers. We don't build trust with magic. We build it with systems that actually work. Systems where people can be heard, where abuse has consequences, where the only ones protected are the public, not the people abusing their power. This isn't about hating cops or loving lawsuits. It's about protecting everyone under the same laws we say we believe in. You can't wrap yourself in the Constitution like a superhero cape, then trip over it the second someone asks you to share. If you liked this episode, smash that like button like it's the legal recourse we used to have. Comment if you think justice should mean more than, well, they had a badge. Subscribe before someone files a motion to silence baby podcasts. This is the Baby Criminologist. Still too young to serve on a jury, but I can smell legal hypocrisy from across the crib. Catch you next time. Don't forget to bring your dignity and a legal pad.